Hi friends, today we are going to discuss cyber law and e-commerce. Before going to the definition of cyber law, I'm going to give you a small example which will help you to identify the subject more accurately. You are in a school or an educational institution. So, you have to wear a uniform and follow some norms and ethics. Similarly, in cyberspace, you are netizens and also you have to follow some norms and ethics of the cyberspace. These norms, ethics, rules, regulations are called the cyber law. Now, going to the definition of cyber law, it refers to all the legal and regulatory aspects of Internet and the World Wide Web. Anything concerned with or related to or emanating from any legal aspects or issues concerning any activity of netizens and others in cyberspace comes within the ambit of cyber law. Now, the legal framework of cyber law. Legal framework of cyber law encompasses all legal aspects of interacting in cyber world. Often this relates to economic aspects of such interactions since it is important to ensure that transactions that moved from real world into cyber world are just as valid and that the rights of interacting parties are safeguarded. Accordingly, contractual aspects of cyber law seek to establish the rules for validity of contracts concluded by electronic means and procedures of enforcing such contracts or resolving disputes arising from such contracts. Now, the components of the cyber law. There are 3 components, as you can see: cyberspace, netizens, and technology. Features of cyberspace. The features are: it's a virtual medium. It is 24/7 into 365. Now, the definition is: it is a conventional means to describe anything associated with the Internet and the diverse Internet culture. The growth of social media, e-commerce, and e-governance has made cyberspace policy a critical issue in India and elsewhere. Jurisdiction has always been one critical issue in cyber offenses. The World Wide Web can be accessed from anywhere in the world and thus touches the boundary of each of the countries and their respective jurisdiction. Literally, any and every offense committed in cyberspace can be called for scrutiny by courts of any or all countries. Now, going to the definition of netizen, as you can see, netizens is defined as an entity or person actively involved in online communities and a user of the internet, especially an avid one. Netizens are also commonly referred to as cyber citizens. Now, we are going to discuss about cyber crime. What is cyber crime? Cyber crime refers to any crime that involves a computer and a network. Cybercrime is not defined in the Information Technology Act 2000 or in the Information Technology Amendment Act 2008 or in any other legislations in India. In cybercrime, the computer or the data itself, the target or the object of offense or a tool in committing some other offense, providing the necessary inputs for that offense. In India, the legislation seeking to grant recognition and legal infrastructure to e-commerce is the Information Technology Act 2000. Now, what are the objectives of the Information Technology Act 2000? First, to grant legal recognition through transactions carried out through electronic data interchange and other means of electronic communications, commonly referred to as electronic commerce, replacing the paper-based communication. Second, to give legal recognition to digital signature for authentication of any information or matter which requires authentication under any law. Third, to facilitate electronic filing of documents with government departments. Fourth, to facilitate electronic data storage. And to facilitate and give legal sanction through electronic fund transfers between banks and financial institutions. Also, to give legal recognition for keeping of books of accounts by bankers in electronic form. To amend the Indian Penal Code, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank of India Act 1934. Now friends, we are going to discuss the scope of the Information Technology Act 2000. This act is applicable to whole of India unless otherwise provided in the act. I'm repeating it again. It is applicable to whole of India unless otherwise provided in the act. The act shall not be applicable to the following. So point-wise, I am going to discuss where this act is not applicable. a negotiable instrument as defined in Section 13 of the Negotiable Instrument Act 1881, a power of attorney as defined in Section 1A of the Powers of Attorney Act 1882, a trust as defined in Section 3 of the Indian Trust Act 1882. Also, the Act shall not be applicable in case of a will as defined in subsection H of Section 2 of the Indian Succession Act 1925, including any other testamentary disposition by whatever name called. Any contract for the sale or conveyance of immovable property or any interest in such property. Any such class of documents or transactions as may be notified by the central government in the official gazette. Again, I am repeating, any such class of documents or transactions as may be notified by the central government in the official gazette. Now, the powers of the central government. Section 87 of the Information Technology Act 2000 confers on the central government the powers to make rules by notifying in the official gazette and the electronic gazette. So, the central government can make the rules only after notifying it in the official gazette and the electronic gazette. Now, friends, we will discuss the notable features of the Information Technology Amendment Act 2008. What are its notable features? First, focusing on the data privacy, focusing on the information security, defining the cyber cafe, making digital signature technology neutral, and defining reasonable security practices that are to be followed by the corporates. So the main points here are the data privacy, information security, defining the cyber cafe, making the digital signature technology neutral, and the practices, security practices to be followed by the corporates. Other features are redefining the role of the intermediaries, recognizing the role of the Indian Computer Emergency Response Team, inclusion of additional cyber crimes like child pornography and cyber terrorism, authorizing an inspector to investigate the cyber offences as against the DSP earlier. Means earlier the DSP used to investigate, now an inspector can investigate the cyber offences also. What is the Cyber Appellate Tribunal? Now it is very important to know this. Cyber Appellate Tribunal has been established under the aegis of the Controller of Certifying Authorities, CCA. It is established by the central government in accordance with the provisions contained under Section 48, subsection 1 of the Information Technology Act 2000. The Cyber Appellate Tribunal has, for the purpose of discharging its function under the Information Technology Act, has the same powers as are vested in a civil court under the Code of Civil Procedure 1908. Now friends, we are going to discuss about e-commerce. Before discussing what is e-commerce, we know that as the business are becoming more and more complex, it is realized that in order to maintain a competitive situation, one need faster processing of the business information. So, the concept of e-commerce arises. E-commerce or e-business consists of the buying and selling of products or services over electronic systems such as the internet and other computer networks. Now, why the main reasons for the spread of the e-commerce is digital revolution? What's that? Almost all the digital devices are connected with one another, and this service is available 24/7. Now friends, as you can see, the goals of the e-commerce, what are the main goals? To reach new markets, to create new products or services, to build the customer loyalty, to enrich the human capital. Also, best use of the existing and emerging technologies, achieve market leadership and competitive advantage. Now, going to the advantages. What are the advantages of e-commerce? The advantages includes businesses without the barriers of time or distance. What does it mean? It means one can log on to the internet at any time, whether day or night, and can transact e-business at his own desire. Coming to the second point, it lowers the cost of sale. How it lowers the cost of sale? No human interaction is there during the online electronic process. So, it lowers the cost of sale. Cheapest means of doing business. Why cheapest means of doing business? Because if we compare it to paper-based business, it is much cheaper than paper-based business. Now, going to the fourth point, you can see less delivery time and less labor cost. Why? Because there is no documentation preparation, there is no other data entry required, and there is no mail preparation also. Another advantage we can say is it provides solution by decimating cost in price fixation. Now, continuing with the advantages of e-commerce, we will discuss the advantages in respect of the buyer. What are the advantages? Reduction in buyer sorting out time. Then there is better buyer decision. Then less time is spent in resolving invoice and order discrepancies, and also increased opportunities for buying alternative products. These are the advantages that a buyer gets from e-commerce. Now, we have discussed the advantages. We will discuss the disadvantages now. The first disadvantage is that few people are using e-commerce. As there is technology phobia, so few people are using e-commerce. Now, The second point it deals with, it is unable to personally examine the product like we do it in a mega store. Second point, we have discussed that we cannot personally examine the product, we cannot touch the product. Thirdly, special and costly hardware and software are required. Now, continuing with the disadvantages, another disadvantage is that website must be maintained and updated regularly, which leads to an extra labor cost. Also, well-skilled and trained workers are required to create and maintain the e-commerce facilities. Another disadvantage is that e-commerce is not suitable for perishable commodities. Electronic Data Interchange, EDI. What is EDI? It is a system where data is transferred electronically in machine-readable and processable form. The moment any message is sent through EDI, then it is immediately processed by the receiving computer without any human intervention or interpretation or rekeying. Now, continuing with it, it is used to electronically transfer documents such as purchase order, invoices, shipping notices, receiving advices, and other standard business correspondence between the trading partners. Now, EDI can also be used to transmit financial information and payment in electronic form. However, where EDI is used for effecting payment, it is commonly known as financial EDI or electronic fund transfer. Now, friends, we are going to a new topic. It is securing the e-commerce and adoption of the digital signatures. Digital signatures are based on asymmetric or public key cryptography and are capable of fulfilling the demand of burgeoning e-commerce by not only providing message authentication, integrity, and non-repudiation function, but also making it highly scalable. Now, continuing with it, another important feature is the involvement of a trusted third party certifying authority to issue the digital signature certificate. As we go ahead with digital signature refers to authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the provisions of Section 3 of the Information Technology Act 2000. Again, I am repeating, it's a means of authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the provisions of Section 3 of Information Technology Act 2000. The idea was to adopt a technology that makes communications or transaction legally binding. Now, continuing with it, the digital signatures is created in two distinct steps. What are the steps? First, the electronic record is converted into a message digest by using a mathematical function which is known as a hash function. Which digitally freezes the electronic record, thus ensuring the integrity of the content of the intended communication contained in the electronic record. Any tampering of the content of the electronic record will immediately invalidate the digital signature. And the second step is the identification of the person affixing the digital signature is authenticated through the use of the private key, which attaches itself to the message digest and which can be verified by anybody having the public key with him. Earlier, we have discussed digital signature. Now, we are going to discuss about digital signature certificate. A digital signature certificate is a mechanism for authenticating and securing the information that is transmitted between two parties. It is an authoritative identification about a person or a company. Again, I am repeating, it's a mechanism for authenticating and securing the information that is transmitted between two parties and an authoritative identification about a person or a company. Now, continuing with it, it is a public key along with some identifying information that has been digitally signed by a certificate authority. It identifies the subscriber, certification authority, and its operational period and contains the subscriber public key. As I have mentioned earlier, certifying authority. Now, we'll discuss the duties of certifying authority. The duties of certifying authority is mentioned under Section 30 of the Information Technology Act 2000. It includes making use of the hardware, software, and procedures that are secure from intrusion and misuse, and provide a reasonable level of reliability in the services which suit to the performance of intended functions. Now, continuing with the duties, adhere to security procedures to ensure that the secrecy and privacy of the digital signatures are assured, and observe such other standards as may be specified by regulations. Every certifying authority shall ensure that every person employed by him complies with the provisions of the Act or rules, regulations, or orders made thereunder. A certifying authority must also display its license at a conspicuous place of the premises in which it carries on its business. A certifying authority whose license is suspended or revoked shall immediately surrender the license to the controller. Again, I am repeating, a certifying authority must display its license at a conspicuous place of the premises in which it carries on its business. A certifying authority whose license is suspended or revoked shall immediately surrender the license to the controller. Lastly, the certifying authority shall disclose its digital signature certificate, which contains the public key corresponding to the private key used by that authority and other relevant facts. Now friends, we are going to discuss the legal aspects of e-commerce. You can see the points which comes under the legal aspects of e-commerce. I'm just repeating it. It's e-security, integration, authentication, jurisdiction, contracts, liability, warranties, taxation, copyrights, patents, trademarks, and domain names. This comes under the legal aspects of e-commerce. Now, we are going to discuss EFT, Electronic Financial Transaction. Electronic financial transaction refers to a process by which money is transferred from one person's bank account to another person's bank account electronically rather than using a check or transferring cash. I'm again repeating, it is transferring of money of one person from his bank account to another person's bank account electronically, not by using any check or by transferring any cash. It also holds true for business and also for companies. Now, coming to e-commerce jurisdiction. In e-commerce, the legal issue of jurisdiction, meaning the legitimate scope of government power, still remains a major legal aspect that is yet to be sorted out satisfactorily. A court must have jurisdiction over the litigants and the claims before it entertains a lawsuit. Now continuing with it, in e-commerce, this issue arises when there is a dispute between business houses from two different states in a country. For example, in India, a customer in New Delhi may be required to travel to Bangalore to defend against a company that is suing him for breaking a Alice agreement. Wider interpretation could be given to the existing laws of physical world to answer such legal issues. Now friends, what are the taxation difficulties in e-commerce? There is problem of tax collection, problem of sales tax, the problem of tax jurisdiction and enforcement, and whether a web server can act as permanent establishment. Traditionally, profits are taxed on two bases. Taxpayer's residence basis, that is the country where taxpayer resides, and source of profit basis, that is a country where transaction took place. However, with the spreading of e-commerce, these two distinctions are getting blurred by giving wider interpretation to the existing taxation laws. Such problems could be resolved. This is a part of our international taxation at the intermediate and the final level. Now, the ethics in e-commerce. What are the ethics? The problems relating to ethics in e-commerce cannot be ignored as it has a legal implication. An unethical act is different from an immoral or an illegal act. Ethics basically is the fairness, justice, equity, honesty, trustworthiness, and equality which are important in e-commerce. So friends, I hope you have understood cyber law and e-commerce. It is an important part of your curriculum. So study this and be an ethical professional as we move towards a digital economy. So be a qualified CMA and serve the nation. Thank you.